Stephen Anthony Aldridge against Mordaunt Estates Ltd.
Good morning.
Good morning.
Please, your lordships, I appear together with my learned friend Rashmi Ramsaran for the appellant in this matter.
Yes.
We are instructed by Mr. Pritam Chetu. My learned friends Joydeep Biari, Shadmini Mutyan, and Namrish Dripol appear for the respondent company.
Yes.
They are instructed by Jean-Christophe Osan Belpo.
Thank you very much.
My lords, I am eager to address you on the merits of this appeal within the parameters of the agreed statement of facts and issues.
Yes.
However, I find myself having to address one matter which is now extraneous to those identified issues, which is at electronic bundle page 454, which is a preliminary objection which has been raised in the respondent's written case.
So just give me one moment
Yes.
to make sure that I've got that in front of me. So just checking, we've got a complete electronic bundle and a supplementary authorities bundle.
Yes.
Those are the two bundles we
So
need.
what was the page again?
454.
454. Okay.
That's the respondent's written case.
Okay.
Ah, yes. Yes, so this is their preliminary.
As their preliminary objection, my first difficulty is that it pertains to an application which has been made ex parte before the Supreme Court under Section 105(2) of the Insolvency Act of Mauritius for leave of the Supreme Court to continue legal proceedings against a company in liquidation, such as the respondent company before us. The application was made and an order was granted by the Supreme Court in April 2026, barely a few months ago. That order is to be found, my lords, at page 403. After the order was obtained, my lords, the statement of facts and issues was put up collaboratively by my learned friends and myself, and no issue was taken on behalf of the respondent in liquidation as regards this order made by the Supreme Court. As regards this preliminary objection, it is also my duty to assist you with the very relevant fact that this order has not been challenged at all in Mauritius by the respondent company, be it by way of an application for discharge or by way of the ordinary appeal process in Mauritius.
Right, so you say it's a simple unappealed.
It's a final order of the Supreme Court,
Yes.
which has been obtained. No issue has been raised in Mauritius as to the regularity of this order.
Well, you've made that point. Can I suggest that we leave it, we'll see what is said
Very well.
on the other side, and
Very
if we
well.
need to come back to it.
I'll come back to that if need be in my reply.
Yes.
Now to the merits then of this appeal, my lords. My lords, as I flew over the territorial seas of Mauritius, making my way here in my airborne carriage, I reflected upon how best to summarize why a miscarriage of justice had occurred in the present matter. And it occurred to me indeed that the best way to refocus the central issues before your lordships in this appeal is a matter of two C's. It is not the C of concurrence in findings of fact by the courts below, which my learned friends for the respondent try to reduce this appeal to. Rather, this appeal brings to the surface errors of law and findings which are plainly wrong within the deeper contaminated seas of characterization. Characterization, first of all, my lords, of the appellant himself, and also characterization of the transaction involving him and the respondent company. The characterization of the appellant, my lords, as a director and a shareholder of the respondent company at the material time is certainly relevant to the issues at hand. Regrettably, though, his characterization during the proceedings before the courts below as a serial litigator was not only irrelevant, but was most unfortunate. As to the characterization of the transaction involving him and the respondent company, it goes to the root of the cause of action of the respondent, then plaintiff, under Section 159 of the Companies Act of Mauritius. It goes to the root of the question whether the respondent company, as a plaintiff having carriage of the proceedings and bearing the legal and evidential burden of establishing all the elements of the cause of action, whether it had been established that Mr. Aldridge, the appellant, then defendant, had been granted a loan to a director, or whether it was in the nature of some other financial transaction involving him as a shareholder. This also begs the question, what was the relevance then of shareholders' approval, which I will use as a term best defining prior approval, or what was also the relevance of shareholders' ratification ex post facto the transaction? Ultimately, this appeal also raises questions as to whether the courts below, in law, properly appreciated what were the four corners of the pleadings on record before them. We submit, my lords, that the courts below ended up making findings which are plainly wrong based on erroneous application of the substantive law, a misappreciation of the incidence of the burden of proof within the corners of the pleadings. They have made findings which are not supported by evidence. They have also regrettably made unsustainable inferences against the appellant, which are not supported by the court record. And the process has been contaminated and must be cured due to other material irregularities, particularly pertaining to the permissible scope of cross-examination and the manner in which the question of forgery was dealt with. My lords, in order to assist you, may I already tell you that over and above the transcripts of proceedings before the courts below, the following papers are key to our analysis. The initial plaint with summons itself at electronic bundle 5 to 10. The amended plaint with summons that came thereafter, which is at EB 30 to 35. The answer to further and better particulars at EB 57 to 61. The admittedly economical plea of the appellant, then defendant, which is at EB 90 to 91.
Sorry, that's the defense, is it?
That's the defense. EB 90 to 91. Document P2 at 195. Document P7 at EB 200. And a controversial document based on issues of admissibility and relevance, which by agreement between my learned friends and myself, we have agreed to put before your lordships, which is the shareholders' resolutions of the 15th of February 2010, which is at EB 405 to 409. We also rely, my lords, on a previous...
And just as I can understand, that's the document that the trial judge ruled, I think, during the trial would not be admitted.
That's the document which was in the bundle of documents already before the trial judge, which the appellant, then defendant, sought to refer to, even before we get into the issue of production, my lord, sought to refer to as forming the underlying facts under cross-examination, under his questions, and which were objected to by then counsel for the plaintiff, now respondent, and which was not allowed.
The document was not allowed
The questions under cross-examination were not allowed
on the basis of the
on
document.
the basis that they were not pleaded as a fact in the defense, even before we get into the actual production of the document.
I had the impression that the judge also ruled that the document would not be admitted into evidence.
Eventually, and that forms part of...
So he did rule.
Yes, yes. You're very right. In fact, this is what we style as a contradictory pronouncement on the part of the learned judge at the time, where she had initially directed that the document could be put in when Mr. Aldridge, then defendant, came to depone, and then she later contradicted herself.
Right. And do we have that ruling by the judge?
Yes.
Can you just point us to that?
My Lord, EB page 158. Lines 8 to 9. EB 158. We are here at the stage where the appellant, then defendant, is cross-examining.
Sorry, just help us. So what's happening here?
You have Mr. Aldridge, the defendant, who is cross-examining.
So it's Mr. Aldridge in person cross-examining who?
Cross-examining the former administrator, Mr. Tommy Lowe, who was called as a witness for the plaintiff. Okay.
Yes.
And during the course of his cross-examination, after having dealt with document P7.
So where do we see that? Where's he dealing with document P7?
As from page 156, my lord.
I see. So
That's-
document P7 is shown to the witness.
Yes.
Right, yes.
And document P7, we'll come to that later on, my lord, is about the alleged loan.
Yes.
And then, because, admittedly, you would have seen from a perusal of the transcript as a whole, every time that the appellant tried to challenge the fact that the transaction was a loan, he sought to refer to the resolution. And the attempt that he makes to cross-examine Mr. Tommy Lowe on the issue is at page 157.
So just before, right, yes, 157.
157. And you will see that the question under cross-examination by Mr. Aldridge was prompted by an answer which had already been given in examination in chief by Mr. Lowe himself. And you have it at 157, where the first question on that page, my lord,
Yes.
Mr. Aldridge is saying, you also said that you researched through all the board papers and company records to look for authorization of a loan. You said that in your witness evidence.
Yeah.
And he's picking up on that evidence in chief, and the answer as well is relevant. Mr. Lowe says, I did not research to look if ever specifically, but I researched, we all go through all the papers, all the resolutions, etc., and there was no paper, no resolution to approve that particular loan.
Right.
And there's an interrupted question on the part of Mr. Aldridge, where he tries to say, of course, in his own words, he says, that's very interesting because there is a resolution on the company records. His question is interrupted by then counsel for the respondent company, raising objection on the basis that it had not been raised.
He says it's the same objection as I took earlier.
Yes.
Can you just help us with the bundle reference where he took the objection previously?
Yes, page 120. Is that it?
Don't see it on page 120. Can you help?
No.
121.
Yes. You will see the systematic reference throughout the proceedings before the court below that Mr. Aldridge was allegedly bound by the contents of his economical plea where there's a general traverse.
Right, but
on that question-
I was asking for assistance with the cross-reference from page 158
Yes,
in the objection by Mr. Ramburn. He says, I've already made the objection. So
Yes.
he's repeating in very summary form at page 158 something which I assume he'd said in greater detail previously.
Yes.
And I was just asking for assistance.
I will find that, my lord. It's in the,
I'm not sure it is page 121.
No,
If you're talking
it's
about
not.
something else.
it's not page 121. Let me
Right.
quickly find that for you. There you have it, page 134. This is at the point of the trial where the appellant, Mr. Aldridge, is cross-examining Mr. Sichern.
So who's Mr. Stephen?
Mr. Sichern was the formal representative of the plaintiff as its company secretary. He was not the witness in support, he was the actual representative of the plaintiff company.
Sorry, when you say he's not a witness, he's being cross-examined, so he is a witness.
Yes, of course. He's not a supporting witness, he came first to actually represent the plaintiff at the trial. And
Right.
the question here, towards the middle of the page, line 16, question reads as, finally, Mr. Sichern, I draw your attention, and this is the first document in the tendered documents, which is the minutes of the shareholders' meeting on the 15th of February 2010 at page 4, item 12.
Right.
And there we have, as from line 21, the objection of then counsel for the plaintiff, objecting on the basis that this is not pleaded, and he even forms the view, which is erroneous in law in our submission, that whatever happened afterwards is neither here nor there. We are on an issue of loan.
Right. And one sees over at 135 the objection is being taken again.
Yes. And there's another attempt at a second question.
Well,
at
so I'm just trying to
135.
follow what's going on. Page 135, the
Yes.
defendant, that's Mr. Aldridge.
Yes.
So
And he asked,
he seems to be explaining that, yes, there is a loan, but it's agreed as recorded in the shareholder resolution of the 15th of February 2010 that it doesn't have to be repaid. Is that was Mr. Aldridge's position?
there's one specificity, my lord. When you look at the question that he asks at page 135,
Right, that's what I was looking
yes,
at, I think.
Mr. Aldridge is not in fact agreeing that it was a loan, and he's putting the very specific question whether at the meeting did the company and its shareholders unanimously resolve that Mr. Aldridge shall have no obligation to repay any drawings from Mordaunt Estates.
Right.
And therein lies the distinction. Because according to the case that he was trying to put forward, it was not a loan. It was approved and validated as being drawings by him from the company with unanimous approval now of the shareholders. And we shall later see that these were approved as drawings and converted into consideration for sale of shares by him
All right.
to an employee benefit trust.
And so Mr. Ramburn says not pleaded.
Yes. And the court, of course, puts Mr. Aldridge to task about the fact that it was not pleaded
Yes.
and that he could have raised those issues.
Yes.
And Mr. Aldridge's interesting answer to that is at page 136, to rely on the fact that he did deny the contentions of the plaintiff in his plea, albeit he did not make specific averments.
But I think the point being made against him was that he could and should have made a specific averment if
Yes.
he was going to rely on this resolution.
Yes, and in law,
All right.
this is where we submit that the court got it wrong, my lords.
All right.
By requiring of the appellant, then defendant, that he should have pleaded more specifically on this issue in order for him to be able to cross-examine on this issue is, in our submission, erroneous in law.
Right, I understand that, but I'm just trying to follow where the court rules on that. So I'm now reading down through page 136.
Yes.
With the judge saying very clearly, you could have pleaded this, and
Yes.
I think she is saying you should have pleaded it, and now you're just raising it out of the blue. I'm looking at page 137.
Yes. And you have page
So
1.
where does she rule on it?
Well, she says you can't go outside the pleading. It's about half.
You have page 138, where what would constitute the ruling is at the top of 138, my lord. You haven't raised this in your plea, so next, is there
Right.
anything else that you may? And then it's interrupted.
And then she says, I've given.
There you go. I have given a ruling. You have to comply with my ruling at this stage.
Right, that's helpful. So through the course of these interchanges, where she's made it very clear that she says this was a matter which should have been pleaded, and she's not then allowing, I think she's still talking about the cross-examination.
Absolutely. Just the questioning at this stage.
All right, and where does she rule that the document itself cannot be admitted?
She never did say that the document could not be admitted. And this is where we say she contradicted herself afterwards. Can you give me the reference?
All right,
When you look at 158, my lord,
yes,
this is the initial stand adopted by the learned trial judge.
sorry, it's not the initial stand. We've just looked at the initial stand. So
No, the
what's-
initial stand on the questioning, that's what we've dealt with so far.
Yes.
The initial stand on the ability of Mr. Aldridge to actually produce the document was at 158.
All right. Where do we see that?
At line, the third,
Line 8 and 9.
yes, 158, line 89. Well, if there's another resolution, if you're saying so, when you come in the dock, you put it in.
Right,
And
I see.
at this stage, my lords, Mr. Aldridge was still pursuing cross-examination. And he responds to say, very good. And this is where we say he did not pursue his cross-examination after he was reassured that he would be able to do so. Unfortunately, when it came to his own examination in chief, this is where the trial judge contradicted herself. The examination in chief of Mr. Aldridge is as from page 165, or rather his evidence in chief, because he was making statements.
So this is 165.
No,
This is
165, this is
Mr. Aldridge giving his own evidence in chief. Is that right?
yes, 163,
163.
yes.
So this is him starting his evidence.
Yes, and he goes straight to the point. He says the most relevant point, which I would like to raise first, is the question of the authorization of the payments that were made to me. He relies on the bundle already put before the judge. He makes mention of the resolutions of the 15th of February 2010. He explains that it was resolved that it was in consideration of the sale of 10% of the holding of his shares to an EBT.
Right.
Then counsel takes issue with this, asking the question, how does he answer this? Because his case is closed. These are matters which come after 2009, again, in our view, on the erroneous premise that it would be irrelevant to the cause of action. And there you have the contradiction. The court says, yes, again, this is a matter which was not raised in the pleadings, and this morning there was already a ruling given as to that, so you will not be able to go into that.
Right.
But she was entitled to so rule, wasn't she?
She would be entitled to so rule based if it was her view about the limitations of the pleadings or the evidence in chief. But as the trial judge having control of the proceedings and having already looked at the pleadings prior to the trial and having reassured the litigant at the cross-examination stage that he would be able to produce the document eventually.
Right, but I mean, she wasn't ruling specifically that he was allowed to introduce it. She was just saying that there will be an occasion for him to seek to do so.
She said so rather affirmatively, my lord.
But she'd already ruled that it hadn't been pleaded.
Yes,
So,
that's correct.
I mean, it could only be admitted as evidence insofar as it was going to be relevant to the pleaded issues. I mean, surely that's inherent in her ruling that the procedure is to be bound by the pleaded case.
But you use the right term, my lord. The right term is the pleaded issues, and those pleaded issues did not necessarily have to emanate from the defendant himself in his defense.
All right.
When you look at the plaint, those issues were pleaded there in the amended plaint with summons.
All right, you're going to show us that.
Yes.
Anyway, I was asking for assistance, and it seems to me that, have you now referred to everything you wanted to
On this issue,
in
yes.
this transcript? Yes, good, thank you.
My lords, before we indulge in that any further, when it comes to the actual appeal itself before the Court of Civil Appeal, my first line of submission before you is that, regrettably, the appeal started on the wrong footing. There was reference made in the Respondent's skeleton arguments filed before the Court of Civil Appeal, and you will find this at EB 231, 232. Reference was made to matters which do not pertain to the actual legal merits of the case at hand. The previous cases involving the appellant and the respondent company were listed. The appellant was characterized as having a modus operandi before the courts of Mauritius and indeed before the Privy Council. This is at EB 231 as from line 23.
Yes?
The respondent back then went even further to remind the same bench that constituted the Court of Civil Appeal hearing the present appeal that they had previously labeled and qualified the appellant as a serial litigator. That's at EB 232, lines 16 to 19.
Yes.
We have been tasked by the respondent's written case that when pleading the appeal before the Court of Civil Appeal, we did not take issue with these observations which were put before their lordships of the Court of Civil Appeal. My lords, we did not feel that we had to do so, because to all intents and purposes, these were irrelevant to the legal merits of the case. And it is also a posit to bear in mind that, contrary to what was being suggested against the appellant never gave instructions, despite the remarks previously made against him by the same bench constituting the Court of Civil Appeal in this matter. He did not give instructions to challenge that bench, because precisely he had confidence in the bench. Unfortunately, when we look at the judgment of the Court of Civil Appeal, and I must say, it would have been something else if these observations had been put before the appellate court, and the appellate court had simply not acted upon it.
So can I just understand this? The submission you're now making is that the appeal court displayed bias against the appellant.
Indeed, this is under our ground 7, that by factoring in these extraneous considerations, which are absolutely irrelevant to the legal merits of the case, because of course, my lords, you will appreciate that it's not because Mr. Aldridge may have failed or even succeeded in previous litigation that his chances should be affected in any way in the present civil suit.
So where do you say they factored this in?
Yes, page 313, second paragraph, as from line 9. The passage reads as, "We note that this is not the first time that this appellant has attacked the integrity of the judges, hearing the several cases lodged by him before our courts. We note equally that the Judicial Committee of the Privy Council has unceremoniously dismissed all his applications for leave against the decisions of those judges." Completely extraneous considerations which ought not to have factored in, my lord.
Well, they noted it, but they haven't said they're relying on it in any particular.
They took note of it, my lord.
Yeah,
For us,
but if you look at the next paragraph, you get the essence of their ruling on this part of the grounds of appeal,
yes.
that the appellant was bound by his plea.
What we submit,
I mean, that seems to be the essence of their ruling.
it's the essence, but
Yes.
as you say, it should have been more than that, my lord, because what we submit today is that this passage from the judgment gives an indication that, unfortunately, there was a predisposed skepticism against the appellant from the very start. When we look at it retrospectively, in line with the principles enunciated by the board in the matter of MCB and Lesage.
Well, but just on the point as to what was the basis for their ruling at page 313,
Yes.
they give reasons which are not affected one way or the other by their view of the appellant, because they just focus on the nature of the pleadings.
Yes, they opine that the learned trial judge had rightly refused to allow the appellant to travel outside his plea.
Yes.
We submit that the possibility cannot be discarded today, retrospectively, in view of their observations made in the preceding paragraph of the judgment, that their judgment had been clouded by these extraneous considerations, and that had it not been for those extraneous considerations, they might have dealt with some matters more thoroughly. And when you look at ex facie the next paragraph itself, on the ground one pertaining to unfairness, this is where we say that regrettably the Court of Civil Appeal failed to identify that there were other salient issues of unfairness to be dealt with, notably the first one that we've just gone through, my lords, earlier, about the contradictory pronouncements of the judge as to the possibility of producing the shareholders' resolutions. They have made no pronouncement whatsoever on this issue. And despite the fact that their attention had been drawn during the appeal that the case of the appellant was that cross-examination on this issue was indeed permissible, and that in broad terms, the appellant cannot be said to have been simply bound by his plea for the purposes of cross-examination. Yet again, they do not make any specific pronouncement on this issue at all.
Sorry, I'm not sure that I followed the point that you're making. Surely the judge ruled at the point where the appellant was cross-examining that a certain line of cross-examination was ruled out because the issue to which that cross-examination went had not been raised on the pleadings.
Of the defendant.
Yeah.
But this is where we feel that this issue in law as to the permissible scope of cross-examination warranted closer scrutiny by the appellate court.
But that just comes back to whether they're right or wrong on the pleadings, doesn't it?
Yes.
Which you're still...
What we're
you're going to help us with.
Of course. But what we're advocating this morning is that we cannot discard the possibility that it's because of those extraneous considerations that the appellate court did not deal with it thoroughly or properly enough.
All right. Well, I think we have that point. Shouldn't we now look at the pleadings? Because this was an important thing both for the judge and for the Court of Appeal.
Yes. When you look at the amended plaint with summons, which was the latest pleading being relied upon by the respondent company as a plaintiff, you have...
This is at page 30, is that right?
Page 30 onwards. And the relevant averments are as from paragraph 7. First of all, the averment.
Paragraph what?
Paragraph 7, my lord.
Thank you.
Line 12. It was made very clear that what the plaintiff was seeking to void was a loan. paragraph 8 enunciates the relevant sections of the law, that is the Companies Act 2001 of Mauritius, that the plaintiff was alleging to have been breached. 1595, 1597, and 1599. My lord, for this purpose, may I immediately bring you to 1599, which we'll have to look at in parallel.
Yes?
At EB 514, 1599 is the provision which confirms that the issue of shareholders' agreement or shareholders' unanimous resolution is of utmost relevance to the cause of action of the plaintiff, makes it a live issue emanating from the plaintiff's own averment at paragraph 8, and this is the starting point where we submit makes it permissible for the defendant to cross-examine about it, irrespective of what is contained or not contained in his plea.
Well, why do you say that? I'm looking at section 1599.
Yes, because it says that the shareholders of a company may by unanimous resolution or by unanimous shareholders' agreement approve any payment, provision, benefit,
Yes,
etc.
absolutely. But if that sets out a defence, if on the face of it there is a payment made which is not properly authorised,
Yes.
it may be authorised by a unanimous resolution
That's
of
correct.
the shareholders.
And
So why, if someone wanted to rely on that as a defence, where it's been shown that they have received a payment, why would you not have to plead that?
I think here the burden is elsewhere. The burden would lie on the plaintiff in order to satisfy the legal requirements of Section 159, and especially given their own averment at paragraph 9 as well of the amended plaint with summons, my lord, that the records of the plaintiff company do not show any unanimous shareholders' agreement sanctioning the aforesaid loans. They have averred it, the respondent company as plaintiff averred it. And you have an administrator at the time coming in and telling you that I have perused the records of the company, and according to him, there is no resolution in the company records approving that loan, rightly or wrongly. So in terms of the legal and evidential burden, we submit that it was incumbent upon the respondent company when seeking an order from the court to void the loan, because Section 1595 contains the restriction on loans to directors, and Section 1597 says that it is voidable at the option of the company. The question then arises in law, my lord, whether this option is available to the company at all in the particular circumstances of each case. And what we say is that it was therefore incumbent upon the plaintiff itself to establish that when it had entered the plaint with summons, seeking the prayers that it sought from the trial court, that the loans are not only, according to them, illegal, should be voided, and therefore the reimbursement of the £615,000 should be ordered by the court, it was incumbent upon them to establish to the required standard that there was no shareholders' agreement approving it prior to this attempt to void it by law.
Well, they said that they hadn't found any resolution. You, at the last minute, sought to put a resolution in, and the court said you couldn't. So simply no evidence.
There was, and this is where we feel that this has not been dealt with properly, because the evidence could have come in two ways, my lord. The evidence could have come in through the cross-examination, which we submit Mr. Aldridge should have been entitled to pursue in order to put the plaintiff's own case to the test, based on the principles that we rely upon in the case law, notably al-wazan, because you have pleaded issues, my lord, and then you have evidential issues. My lord, you will appreciate that cross-examination...
You couldn't put anything unless he's allowed to rely on the document.
Sorry, my lord?
There's nothing for him to put unless he can rely on the document, which the judge said he couldn't because it wasn't properly put in evidence.
Disproving the plaintiff's case, my lord, in my humble submission, did not necessarily require that the document itself be put before the judge. If we keep the issue of production of the document on the side for a moment, the real question we should be asking ourselves is, wasn't Mr. Aldridge entitled to ask this question or pursue this line of questioning against the plaintiff's representatives in order to establish, or disprove rather, disprove is the better word, the plaintiff's own case that it was allegedly a loan. He was entitled in our submission to put the plaintiff's version to the test. He had denied that version as being without substance or merit. And what he was seeking to do is to not only discredit the plaintiff's version that there was no resolution whatsoever in the company records to that effect, but purely and simply that the transaction for which reimbursement of the monies was sought was not a loan. And if we stretch what he was trying to do at the trial, is also that eventually, even if initially it was some sort of credit arrangement, because you have evidence, my lords, of the fact that there was not only an alleged loan according to the respondent company, but you have admissions on the record before the trial judge that there was an operations current account between the two parties, where monies had been put in by Mr. Aldridge himself and monies had been taken from the company. He was entitled to establish that ultimately, although the initial transactions were during the period 2008 to 2009, ultimately, by the time it came to February 2010, the nature of the funds held by him had become consideration for the sale of shares. And you would have remarked, my lord, that the plaint itself, the initial plaint, dates to May 2011. So more than a year after there is a shareholders' unanimous resolution on the record validating as consideration for the sale of shares and spelling out that the £615,000 which are held by Mr. Aldridge, he shall have no obligation to repay it to the company. More than a year after that, you have the administrator representing the respondent company seeking to void and seek the reimbursement of those monies on the basis that it was a loan and on the basis that in his appreciation, he had not seen any records, any shareholders' resolution in the records of the company validating the loan.
Well, if you were saying it's not a loan, that's something you should have pleaded.
It would have been better.
No, you should have pleaded it if that's a positive case.
It is the positive case of the defendant that it was consideration for the sale of shares. But given that we take the plea as it is, and that it was a general traverse, and I'll be the first person to tell you that it was not an ideal plea. But allow me to use a fitting analogy, my lords. I don't want to be humoristic about it, but let's just say that when he stepped into that trial, Mr. Aldridge carried into that trial a yellow card on this issue, and he had to tread more carefully on the issue, given that he didn't plead it as part of a positive case. But we submit that when it comes to the question of the resolution of the 15th of February 2010, the fact that Mr. Aldridge had relied upon a general traverse in his plea did not transform this into a red card, preventing him from tackling the plaintiff as his opponent at the trial on this issue. Because, from another perspective, this cross-examination, this questioning, the reliance on the facts contained in that resolution in his favor, also enabled him to disprove the plaintiff's case that this was allegedly a loan which he had to reimburse.
Just on that point, can I just check, page 408 in the bundle, is that the relevant part of the February 20?
Yes, resolution number 12.
Yes.
This is indeed the relevant part, my lord. And the emphasis here is...
So that is expressed on the basis that Mr. Aldridge acknowledged receiving drawings from MEL
Yes.
in the past, and the first time that it's resolved that these are going to be consideration for the sale is in this resolution of February 2010.
If I may be more precise, my lord, it is when you read at resolution number 12-408, it's not only Mr Aldridge acknowledging having received drawings. The company as well is acknowledging that the funds held by Mr Aldridge are in the nature of drawings.
Yes. My point was a timing one. So the drawings have happened.
Yes, of course.
And then
It's
you get
afterwards.
this resolution.
It's ex post facto validation of the funds already held by.
How could the drawings be anything other than loans?
Because you also have the issue of operations current account.
Right, but if it's a drawing, why would it not be a loan? It may be a loan in the context of a current account, but it would still be a loan, wouldn't it?
A loan is rather specific in my submission, my lord. And I think this is presumably why the administrator felt that he had to rely specifically on document P7, which allegedly contained more detailed terms as to repayment and so on.
Right, all right.
If I may put it
But
this
there are two separate issues on
Yes.
the note. One is whether or not it was a loan,
Yes.
but you would say, actually, irrespective of that, there has been this company resolution which has in effect waived any obligation to pay any money by Mr Mordaunt, by Mr Aldridge.
That's correct.
So it doesn't really matter to your case whether it was a loan or not, because you could say it's sufficient to rely on this shareholder resolution.
In the letter and spirit of the law and the statutory framework, you would be absolutely correct to say that ultimately it did not matter. Because at the time that the plaint was entered, the company, through its shareholders, had already taken the decision that there was no obligation to repay. And you would have noted, my lord, I'm sure you have it, this is why we have recently also favoured you with section 272 of the Companies Act, which joins the provisions of section 159, where in our submission, the cumulative effect of those sections of the law is that ultimately the fate of those funds, whether a loan or otherwise, is left to the validation and appreciation of the shareholders. And when you have a company, unanimously through its shareholders, having already resolved that there shall be no obligation to repay ever since February 2010, can the court even intervene to find the opposite? And the opposite is what the plaintiff company was seeking as an order from the court.
But in a sense, if that's right, it would have been so straightforward to plead in the defence any obligation we might have had has been waived by a unanimous shareholder resolution, but that wasn't done.
That's correct. That simply wasn't done. And Mr. Aldridge would have been much better off had he done so.
Right.
That's why I submit that in the assessment of where the evidential boundaries lie, the trial judge put a lot of emphasis on the fact that this was not pleaded. I am not supporting the position as contained ex facie the defence that because Mr. Aldridge was not communicated with relevant documents and so on, as he states in the instructions he gave when filing the plea, that he was not able to file a more comprehensive plea. But we have to take it as it is. And even when we take it as it is, my submission before your lordships is that this did not absolve the plaintiff of its own responsibility to establish all the elements of its cause of action to the required standard. And one of those elements was precisely to establish that the company had not already otherwise dealt with it.
But in a sense, if you're talking about waiver, it would be required on the defendant, I think, to put that forward. It would be regarded normally as a form of defence.
It would have been better if this fact was pleaded as part of his defence.
And then the issue might have been, well, is the requirement in the Companies Act, subsection 9, satisfied? Because is the company likely to satisfy its solvency test?
Yes.
Might have been an
Yes.
issue
Yes.
that would then be raised.
Yes.
So you might say that the judge has acted perfectly properly by saying, well, I'm not going down this because it's not been properly pleaded.
I think before we reach the defense case, the trial judge and the Court of Civil Appeal, in their analysis of the evidence, when matched against the elements of the cause of action, should have asked itself whether the plaintiff had discharged its own burden.
But doesn't that come back to the same question as to where the onus lies in pleading terms to raise this as an issue? I do understand that you're making the point that, in effect, it was incumbent on the plaintiff in pleading terms to negative any possible defence that might arise under Section 1599.
No.
Oh, you're not saying that?
We're not saying that they have to go that far as to negative any defence.
All right.
What we're saying is that in order for a cause of action under 159 to survive, it is incumbent upon the company seeking to void the loan to establish ab initio in the first place that it is still entitled to do so. And the only way that the company can establish that it is still entitled to do so is by satisfying the court of two things. First of all, that there hasn't been, prior to initiating the judicial process by way of plaint with summons, that there hasn't been any prior or post shareholders' approval of the financial transaction.
I think that's exactly what I put to you, but you said that wasn't your case. But
No,
now
no.
it does sound as though
Yeah,
you're...
not as a defense, not as every possible defense. There can be other defenses, but
Right.
in terms of the ability...
But I put to you as a defence under Section 1599.
Yes.
And
Yes.
so you are saying, yes,
Yes, yes.
that it was incumbent on them in pleading terms to establish that there was no possible defence under Section 1599.
Yes.
You are saying
I would rather formulate it as an element of the cause of action themselves, not from the defense perspective, but rather to show that for a company to be entitled to void at its option, this option is only available to the company if the shareholders haven't already resolved otherwise. If the shareholders have resolved otherwise, then they don't have that option.
I think we have that submission. I'm very conscious you have about 10 more minutes to cover all your other grounds of appeal.
And
so I think we do understand that submission. Yes, do say
the second
whatever you
element,
want.
to answer the earlier question, about the solvency test as well. It was also incumbent upon the plaintiff company, in the discharge of its legal and evidential burden, to satisfy the court that eventually, when the transactions were made, the solvency test, as defined in Section 6 of the Companies Act of Mauritius, was not satisfied.
Right.
And our submission is that there was still no evidence that
That sounds like it's bound up with your first point. I mean, if it's right that it was incumbent in pleading terms for the company to show that there was no defence under Section 1599,
yes,
that would cover both, whether there's a resolution and also
the solvency test
as well.
Yes, but we wish to draw your attention that on the evidence, in application of the law, I have seen no evidence to establish that at the time the transactions were made, because you only have Mr. Tommy Lowe as the former administrator coming as a witness on behalf of the plaintiff's case and saying that when he stepped in 2011 and decided to initiate this case, the respondent company was in a near insolvency state.
Right.
But there's no evidence whatsoever on record to suggest that between 2008 and 2009, and even at the time of the shareholders' resolutions in February 2010, that the company, after making those payments to Mr. Aldridge, and at the time of validating them as consideration for the sale of shares, that they were in any way not satisfying the solvency.
But I think the company would say on that, what they would say would be, we didn't need to put in evidence about that because the issue of a resolution under Section 1599 had not been raised on the pleadings. Now, they may be right or wrong about that.
Yes.
That would be their explanation, I think.
And my answer to that explanation would be that they said it themselves.
Right.
In their plaint with summons.
Yes.
They said that there had been allegedly a breach of 1599.
Yes.
And in order for them to establish that breach, as you rightly pointed out earlier, there are two elements of 1599.
Yes. I do think we've got that point. If you want to take up time
I just want to
promote any of your other grounds of appeal,
yes,
I think
on the analysis of documents P2 and P7, over and above what is already elaborated upon in my written case, I wish to draw your attention to the mistake that the court made. Because the respondent company, as a plaintiff, was relying heavily on document P7 as being the document which establishes the loan.
Yes.
When you look at document P2, And for me, it defies logic, my lord, that you had a plaintiff who was claiming that document P2 was a photocopy of the document P7 original, when they are glaringly different. When you look at document P2 at 195, and you immediately compare it with document P7, words have clearly been added on the version of the same document which is produced as document P7. Now, what I wish to draw your attention here is when the trial judge found that the contention of forgery by Mr. Aldridge was, according to her, a last-minute fabrication on his part, this prevented the judge from getting into the comparative analysis of the documents and to actually make a finding of forgery. I do not dispute the case law put forth by my learned friends for the respondent, that it is for the judge as a trier of fact to determine whether to act on the allegation of forgery or dismiss it outright, as the judge did here, but it needs to be based on the correct inferences being made against the appellant.
My understanding is that the forgery issue goes to document P7.
Yes.
But it was not being said that document P2 was a forgery.
No.
So document P2 was accepted as a true record.
Document P2 was accepted as being a true record, but may I here draw your attention, and I presume this is why the plaintiff was not happy to rely on document P2 alone. Document P2, ex facie, simply says that Mr. Aldridge is confirming that the amount due to the company is £615,000. A loan, my lord, gives rise to an amount due, but an amount due does not necessarily mean that it is pursuant to a loan. It could have also been the operations current account that was admittedly ongoing between the parties. And I feel that this is why, when it came to document P7...
I'm so sorry to interrupt you on that. That's a part of your submission that I'm not fully understanding. Why, if monies have been given, to use a neutral expression, to Mr. Aldridge on current account, would they not count as a loan to him?
Because a loan is, in my view, a very specific financial contract. That's why the plaintiff company itself made a distinction between the operations current account and a loan. And Section 159 applies only to a loan. When you have the authority of Ciro Citerio, for example, that I cite in the bundle, you will see that it is spelled out that a loan, when not voided, and when it stands until it's voided, property in the money transfers to the borrower.
Right.
And I think it makes a material, and unfortunately, the Companies Act of Mauritius does not actually contain a definition of the law, of a loan. But I think it would be inaccurate to assimilate any credit in favor of a litigant such as Mr. Aldridge as constituting a loan.
Yes.
So
It could be an overdrawn current account by funds from the company. And therein lies the problem at the root of the cause of action as well, in my submission. And this brings us to why I feel the plaintiff company, in the conduct of the trial, felt that it was necessary to say multiple times that document P7 was the one that they were relying upon as establishing the loan. And the material differences being that P7 spells out for the first time a period of repayment, being on demand, specifies that there's no interest, specifies that there's no security. These are the terms which, if this document was authentic or authenticated, then would be indicative of a loan, but not document P2 alone.
Which was the one that was exhibited to the complaint, the pleading?
Which was the one?
Which was the document attached to the pleading?
There was no document attached to the pleading, and this is the mistake that the court made. You have before you, my lords...
The plaint refers to documents, doesn't it?
Yes, paragraph 8 initially of the initial plaint contains words in brackets saying that the document, that is the letter dated 14th of October 2009, is a document which is annexed. And this is where I think the court made a mistake. My lords, you have before you a reproduced record of the papers before the courts below, which has been certified at pages 359 and 360 in particular of the bundle as being a correct reproduction of the court record.
So can you just give me the bundle reference to the document that is cross-referred to in paragraph 8 of the initial plaint?
The Paragraph 8 of the initial plaint is at page 6.
Yeah, so that's, I was asking for, where's the document?
Where's the document, which is annexed? There's no document. That's
Right,
why.
that's just a mistake, is it?
Yes. And
All right.
when the trial judge found against the appellant that he had already seen the document ever since the document was served upon him on the 7th of June 2011, and you have the service confirmation at page 10 of the electronic bundle, you will remark, my lords, that the usher, when serving the plaint himself, confirms that the foregoing plaint with summons was duly served by me. He does not refer to any documents annexed thereto having been served.
Right.
This document, had it been annexed to the plaint, would have been in the papers in front of you immediately after the plaint.
So was it requested or?
It comes afterwards in the exchange of particulars,
Right.
where the court makes another mistake, page 59, when, of course, it's not important that actually the trial judge got it wrong because he referred to the wrong question and answer because there was a letter sent to the administrator by a shareholder. But the relevant part is page 59, line 10, question 6, page 59. Under exchange of particulars, which would have been another opportunity for the document P7 to be made available, the defendant was moving for communication of the letter dated the 14th of October 2009. This copy was said to be available for inspection, and the only document which was represented as being a photocopy was document P2. And the judge used this answer to infer, unsustainably in our submission, that it was document P7 specifically which had been communicated. And we say that this is a mistake, because it could have been, and it could not have been the original. The original was not even in the possession of the respondent company. It was produced by the representative of Grant Thornton, an accountant, as a witness, having custody of that original document P7.
Right.
I'm not
And the
quite
last point,
clear. What are the drawings that would be that Mr Aldridge would be entitled to if he's not been loaned money? What are we talking about?
I think we're talking about the operations current account that is referred to in the evidence, where Mr Aldridge was putting money into the company and was also getting his money back to some extent, and those accounts were never, it would seem, accurately reconciled. And that's why you have the whole history of litigation, and I'm coming to this point. You would note that we have relied on the previous judgment in litigation involving the parties, dating back to 2013, where you have the respondent company itself coming on the record in an affidavit to say that according to them, and we're talking about prior to even initiating the present plaint, they say that Mr Aldridge had himself already repaid £230,000 out of this alleged unlawful loan of $615,000. And yet, when they initiate the present proceedings, they come and claim the full amount. And this goes to the root of the question that you are asking, my lord.
So where's that reference?
For the £230,000?
Yeah.
Yes, the previous judgment is as from page 519, where the judge in that matter cites verbatim all the resolutions, and you will note at EB page 530, the judge listing out the contents of the respondent company's own affidavit, a statement under oath, saying that on or about December 2009, the petitioner, that is Mr Aldridge back then, returned to the respondent approximately £230,000, understood to be a part repayment.
Well, that seems to be acknowledgement that, insofar as that's referring to the current account, that
No.
he was...
If you look at page 531, my lord.
Sorry, so why are you showing us this if it's not a reference to the current account?
No, it's not a reference to the current account,
All right.
just to show you that it was their own version that £230,000 was a part repayment of the loan, and then they claimed the full amount. And then when it suited them in the present matter, because these are the submissions that were made by then counsel for the appellant before the Court of Civil Appeal, it was then suggested in these proceedings that the £230,000 was as part of the operations current account. So we submit that in seeking to get their hands back on the £615,000, which had already been validated, the respondent company kept on putting forward an incoherent and contradictory case against Mr. Aldridge.
Yes. Now, Mr. Abdullah, you're into a period outside your allotted time for opening.
Yes.
The board will allow you to use up your time for reply insofar as you want to, but just be aware that that's what you're now doing.
Thank you.
So, do you want to proceed and use up some of your reply time, or have you said sufficient for your case?
I think we've dealt with the major problems with the decisions of the courts below. And of course, as regards the assessment of damages of 2 million rupees, which is incidental and which would stand or fall depending on the outcome on the other issues. But we submit that in any event, even that finding was simply unsupported by evidence as to the actual material damages that the respondent company had suffered in consequence. I will leave everything else for my reply after having heard my learned friend.
Yes. Thank you. So, Mr. Bihari?
Yes, my lord. So, my lord, I shall address the board, first of all, with respect to the preliminary objection which was taken by the respondent. I will take the board to page 401 of the EB, where the notice of objection was taken for the first time by a respondent. And it is only as a result of that notice of objection that the appellant actually proceeded to seek leave before the Supreme Court, and same was obtained on the 24th of April 2026. That order was obtained as a result of an ex parte application.
Right. But it's not been appealed.
Sure.
So,
But
so why? I'm struggling to understand how you've got a valid preliminary objection where there is a relevant order made which hasn't been appealed.
In fact, my lord, the order was made on the 24th of April, and the case was already pending before this board. And the case of Manhattan came in 1 month later, sometime in May 2026, which is the copy of same is in the brief at page 789. In fact,
this is an
case
authority
before the Supreme Court.
Yeah, sorry, this is an authority. Where does it begin? Just to help.
It starts at 785, my lords. And I will refer your lordships to the page 789 and 788. The last paragraph. It is also clear that section 1541 does not prescribe any application for leave. Where a company is in liquidation, the legislator has specifically provided that there can only be a final court order as opposed to a leave order, and this too for the limited purpose of commencing or continuing legal proceedings against a company or in relation to its property. And the next page, furthermore, in view of the provisions of section 1541A of the Insolvency Act, which vests the liquidator with the custody and control of the assets of the company, which is very important, my lord, the court would fail to act judiciously if it were to proceed to make an order pursuant to that section solely on an ex parte basis.
So that might have afforded you excellent grounds for an appeal to the Court of Appeal, but you didn't appeal.
No, this judgment before the Supreme Court of Mauritius says that in case of liquidation, you can proceed only by way of 154. And this is upheld by the judgment before this board at page 805, the judgment starts, paragraph 76. And that, your lordships would take note that that judgment was given on the 14th of May, 2026. And at page 826, the Court of Civil Appeal was, paragraph 76, was rightly critical that both the leave order and the derivative order were made without notice to the joint liquidators and without any opportunity for them to be heard. Orders should be made on an ex parte basis only in exceptional circumstances, such as where giving notice might well frustrate the order sought.
Yeah.
So,
Same comment applies, doesn't it? This might have afforded you excellent grounds for an appeal to the local court, but you didn't appeal.
When the ex parte application was done, it wasn't served upon us. It was only afterward, during the course of this present proceedings, that we were made aware of that leave order which was done ex parte.
And you could
and it was already pending before the...
Right, but you could have appealed. So, so the order purports to give authority for the appellant to proceed with the appeal, as I understand it.
It was our right. It was our right to proceed with it.
And you could have challenged that order in the local courts, but you didn't. So why is it just simply not an unappealed order which gives authority to the appellant to proceed with its appeal?
Like I said earlier, my lord, it was because the case was already fixed to be heard here, and we thought of, instead of going for appeal before against that order in Mauritius, that would be taken here. But more so that we had raised it at page 401, like we said, and it was as a result of that we went for application for leave.
Yes, but all right. Okay, I think we understand the point.
Yeah, it was the timing which was a bit short and constrained. This is why we thought of bringing it here.
Yes.
In any case, I'll go to the merits of the case.
Yes, thank you.
My lord, the gist of the appellant's case before this board today revolves around the infamous shareholders' resolution dated the 15th of February 2010, and which I haste to add.
Well, you say that, but I mean the opening point that was raised on the appeal was that there was an appearance of bias on the part of the Court of Appeal, I think.
That's under ground one. I'll come to that.
All right. Okay.
But
Just that you seem to be...
most of it's around the shareholders' resolution and the fact that neither the trial court nor the Court of Appeal gave credence and importance to that shareholders' agreement.
Yes, very well.
And which I haste to add did not form part of the plea. This is the uphill battle which the appellant has to face today. And it is clear from the grounds of appeal, the way they've been couched, from the appellant's written case, that with all due respect, that the appellant is making an attempt to rewrite his case, which was probably handled with some impropriety or negligence on his part. Today, the appellant is moving from this board to find in its favour by making abstraction of a well-settled principle and with respect to pleadings. I will humbly submit on this side that this is an invitation to open wide floodgates for impropriety with respect to pleadings to happen in future. My Lords, my friend has been time and time again referring to the learned judge's reluctance to have the document ushered in by the appellant. I will take your Lordships to page 97 of the EB.
Sorry, 9-7, did you say?
9-7. Which is the beginning of the trial before the Supreme Court. And it is very important to note that the appellant was represented by a law practitioner. Even he was not represented by counsel. He was represented by a law practitioner, the attorney. And the attorney came forward and put in the list of witnesses and the notice of tender of evidence and the writ of subpoena at page 97 at top.
This is Mr. Chutu, is that right?
Yes, the fourth line. And then at page 102...
And the tender of evidence, is that a document?
In fact, this is what my friend has been talking about, the practice, the curses in Mauritius. It's not proper. This has been actually canvassed before the Court of Civil Appeal. What do? They put in the notice of tender of evidence, which is a kind of list of documents which would be produced, but at the same time they put in the bundle as well, for ease of reference, I take it. And this is why, at one moment in time, they said that such evidence was ushered in bulk.
Right.
When
Can I just start? Do we have the notice of tender of evidence
in this
that's
in the brief?
referred to here in our bundle?
No.
Right. But was there such a document?
Well, it is accepted by that was indeed a bundle which was put in.
So when the notice of tender of evidence is referred to here, is that just simply the bundle being put in?
The bundle and the list of the documents in there.
Right.
Yes. So notice is the list and the bundle of documents which have to be produced individually afterwards.
And I think you're just telling us that there was a separate list, which was the notice of tender of evidence that went in with the bundle.
We don't have evidence of same, but we have evidence that the bundle was before the judge.
All right.
Because she refers to it, she says it was not paginated and whatnot during the proceedings.
Yes.
Yeah. I'll take your Lordships to page 102 of the brief, with Mr. Ramburn, the last comment of Mr. Ramburn, counsel appearing for the plaintiff at the time. Well, before the case starts, let me make an observation. Since my friend is on his feet, I'm going to object to any evidence from the defendant because look at his plea, there is no averment. So, my lords, the appellant, before the trial actually started, had notice of the stand of plaintiff, i.e., that the plaintiff would object to any kind of evidence extraneous, because the word was used by my friend at ground 7, extraneous to the plea. And in spite of this, and in spite of being assisted by a law practitioner under the Law Practitioners Act of Mauritius, there is no motion to amend. There is never any attempt to amend the plea. This in my humble submission, my lord, would have been a more suitable course of action in favour of the appellant. And since, we're just surmising, since the appellant was not represented by counsel apart from the attorney, the court, should there have been a motion for amendment of the plea, could have been more sympathetical towards the
Right, that may be so, but I understand the argument on the other side before us to be that there was no need to apply to amend the plea because the whole pleading burden was on your clients. That's the argument that you face, that they didn't need to amend the plea, their plea, in order to raise these points at trial.
I obviously beg to differ because we have put in enough
Yeah,
evidence.
I'm not expressing a view on that. I'm just saying that would be the answer to the
That'd be
point
our
that you're
argument.
now making,
Right.
that they would offer.
And at one moment in time, there were questions put by your lordship with respect to the ruling. In fact, the ruling is found in two places.
Right.
At page 138, for the first time,
And when you're saying
judge.
the ruling, which ruling
the
exactly?
ruling not to have the resolution ushered in because it was not pleaded. And then at page 165, and very importantly, before I go to 164, 138 in my humble submission should be read together with 137. This is where the discussion starts. At page line 14, court 137. No, there are procedures which are to be followed. You have given a plea. You have an attorney, even if you don't have counsel. You have an attorney who can advise you out, I would hope, so don't travel outside your pleadings. Otherwise, you will have to put in material that you wish this cannot be. Right. And that discussion goes on the next page, Mr. Ramburn, but I'm objecting to this. The court, you haven't raised this in your plea. So next, is there anything else you may? With respect to your ladyship, the appellant goes on insisting, and this is when the court says, I have given a ruling on this. Now, going to, like I said, page 165.
165.
164, sorry.
164.
163, per line 20. Court. Yet, yes, again, this is a matter which was not raised in the pleadings. And this morning, there was already a ruling given as to that. So you will not be able to go into that. And this, such comments, such remarks are made by the court time and time again. Because the reason behind it is because this wasn't ushered in. It was not mentioned in the plea. My friend is harping on his constitutional rights, the appellant's constitutional rights, and his rights to fair trial. What about the right of the respondent to know what is the case he has to meet? What about the right of a respondent to ask for particulars of a plea, should a proper plea have been filed? What about the right of the respondent to file a reply as a result of answers to particulars on the plea? Both litigants have got rights, and this is why I've been saying all throughout the written case, this is the basic rules of evidence and basic rules of pleadings. This is the problem they are facing today. And better still, my lords, the appellant has been laying at the doors of everybody his inability to put in the impugn the shareholders' resolution. But funny enough, he had the chance to do it. If we go to page 166, he had a golden opportunity to put in when counsel for the plaintiff cross-examined him and opened the door for him to put that document. And he did not. No, I take your lordships to that. No, according to you, were there any resolution or not to approve those payments to you? Yes. The next question is still, where are they? I'm apparently not allowed to submit further documents. So, in spite of all
that's him referring back to what the judge had ruled on before, isn't it?
Yes, certainly. But I mean,
So in what sense is it a golden opportunity?
This was a question put in by counsel for the plaintiff in cross-examination.
Right, and the answer the judge has told me I can't do it.
But he didn't even try. He just said, he at this moment said, where is it? The door was opened by no less than counsel for the plaintiff. If you had put in that document, here it is, what would have been the reaction of the judge then?
Right. Well, you probably have said, I've given a ruling on this, you can't do it.
But then it was self-inflicted on the plaintiff, if I may put it that way. Because
it's the self-inflicted bit I'm struggling to understand.
The counsel asking, where are they? It was this is it. It's not. The motion didn't come from the appellant. It came from from counsel leading him. Giving him a chance to produce that. This is my point with respect to saying. But he didn't. He said I'm apparently not allowed to submit further documents. Now, this is with respect to ground one, amongst others. Also, during the course of his submission, my friend has, in fact, my lords, I will also take your lordship to page 273 of the brief, where the appellant himself before the Court of Civil Appeal there's an admission that the last paragraph, I must admit that this document was persistently dismissed on the ground that it had not been pleaded by Mr. Aldridge, and therefore, let's call it tough luck, he ought to have done better in his pleadings. They admit their plea, it was economical. And
sorry, I didn't find that passage. I'm probably on the wrong page.
He ought to have done better in his plea.
Which page are you on, sorry?
Page 273.
It's the bottom of the page.
The last line.
Yes, thank you very much.
So this is... Who's speaking here?
Counsel for the appellant.
Right.
And if we go back to page 90, which contains the plea, what is the excuse provided by the appellant when he finds what he calls his economical plea? He says at paragraph 3, consequently, defendant has not been provided with sufficient particulars to enable him to prepare his plea. However, on the trial date, like David Copperfield, all of a sudden, he comes up with this shareholders' resolution dated 15th of February 2010. And this is not, this shows his bad faith. And this shows that at all times he was aware that there was that shareholders' resolution. And in fact, during the course of submissions, before the Court of Civil Appeal at page 271. Again, counsel for appellant submitting. So, I would now like to draw your lordship's attention to this document. Last paragraph, page 271. The last paragraph. So the resolution, my lords, which was part of the bundle at page 108 of the brief, this is the document which has been put many times before our courts. Many of our judges know this document by heart. It is the minutes of proceedings of shareholders of Mordaunt Estates on the 15th of February 2010. So at all times, he knew he had that document. So coming and saying that he didn't have enough particulars, in my humble submission, is neither here nor there and smacks of bad faith. Now, it is also his case that his rights have been breached. If you go through the proceedings, my lords, you would see that so many times that from the moment the trial starts, the learned judge shows much latitude towards him. And each and every time, he's reminded of the fact that that document that averment wasn't found in his plea with respect to the shareholders' resolution. And during the course of submissions before the Court of Civil Appeal, counsel for the respondent then earmarked and highlighted those instances. Coming to the issue of extraneous material being relied upon by the Court of Civil Appeal. Those...
just to be clear, is this the part of the case that's been presented in terms of the Court of Appeal referring to the appellant being a serial litigant and so on? What do you mean by the extraneous?
This is... with respect to the character, this is what my friends started
yes.
Submitting on the character at page 313.
Yes, thank you.
Yes. The second paragraph. This is we had questions from the board with respect to that part being the determining factor of the judgment.
Yes.
In fact, the extraneous matters, as they are called, are various authorities implicating the appellant in different other court cases. And that was brought in mentioned by the counsel for the respondent before the Court of Civil Appeal in his skeleton arguments. And at page 232 of the brief, several cases were quoted. And this is why my friend is saying that the Court of Civil Appeal was wrong to rely upon this. But it is apposite to note, my lords, that when those skeleton arguments were put in by respondent's counsel then, appellant's counsel did not object to same, nor did he reply to those extraneous matters. And at page, in his, I will take your lordships to page...
But I mean, if those matters were improper to be taken into account, and the Court of Appeal did take them into account, that would make it improper, wouldn't it, whether or not the appellant had objected?
No, it doesn't make him proper. This is, but what I'm saying, to take this point before the board now, in my humble submission, this is a right which they cannot avail themselves of because they did not take the point there. It doesn't go to say that it makes it proper or not. But then we come to the point whether the Court of Civil Appeal relied upon such characterization to come to the conclusion as they did. Because as your Lordship rightly pointed out earlier, when we go to the next paragraph, it was a matter of pleadings which came up again. This is, in our humble submission, the determining factor. But better still, my friend himself, at page 439 of the brief, which is paragraph 5.10, my friend himself quotes lengthily from the judgment of Aldridge and Mordaunt Estate 2013, SCJ 92. This judgment, and he quotes from there affidavit and so on and so forth, and this judgment forms part of those authorities which my friend calls extraneous matters. And it is my humble submission, my lord, what is source for the goose should be source for the gander. So that with respect to extraneous matters. Now, my friend also makes a distinction between indebtedness, which is in P2. There is no denial of P2. P2 is not unchallenged. It's P7 which is challenged. And the only difference between P2 and P7 are the words on demand and a signature on top, I believe, as well. But the appellant does not contest his signature on P2. So, what goes unchallenged, therefore, is that there was an indebtedness towards the company. What is the reason of that debt? There is no evidence on record. However, why we say that it is a loan? When we go through the evidence of Mr. C. Churn at page, first of all, the evidence of Mr. Nubby, representative of Grant Thornton, at page 139. Line 23. The last question. During the course of...
So sorry, I missed
139.
139, thank you.
During the course of your audit, can you tell the court what are the matters which you do and what you ask for the company? There was a loan of £615,000 sterling. There was a loan. Where did you find that? In the ledgers provided to us for audit. In the ledgers provided to you by the company, and then you found that there was a loan of £615,000 to the benefit of whom? I correct myself, £615,000 sterling, £615 sterling to the benefit of Mr. Aldridge.
And is this evidence in chief?
That's in chief of Mr. Nubby.
Of Mr.
Nubby, the representative of
Nubby.
Grant Thornton.
Yes, thank you.
And so, and Grant Thornton was actually the auditor of the company. And when we go to the cross-examination of Mr. Sichern,
Well, first of all, was there cross-examination of Mr Nabi on this part of his evidence?
I'm sorry, of Mr. Nabi. This is what I'm sorry, it's not Mr. Teacher, Mr. Nabi.
So you're taking us to
Yeah,
cross-examination?
it's Mr. Nabi who is the auditor.
Yes, all right.
When you go to his cross-examination, exactly, your lordship preempted what I was about to say. This is not challenged.
Page?
141, 142. Nothing is said about the ledgers or that loan issue. And when the deed administrator, Mr. Low, deposed at page 145, starts by
I'm so
145.
sorry, just to understand what's going on. Page 142 at the bottom, there's a question, is it possible that this is a fabricated document? Which,
Sorry, my lord, which page?
page 142,
Yes.
at the bottom of the page, line 28. The question is it possible that this is a fabricated document? Which document is being referred to there? Is that P7 or is something else?
Yes, but he doesn't specify, again, he doesn't specify. He's talking about this
looking at
document.
140 and 141, he says he's got an original in his file.
Talking about P7.
He's talking about P7.
Not
He talks
P2.
about it being on demand. The next page.
He's still with P7. He's not talking about he's talking about his case about this addition of the words on demand.
And then it's put in, it's 141 and marked as P7.
Yes.
Right. So it is P7 that's being talked about in that question. Yes.
And it's come out of, it's an original in their file.
So his case is always about P7.
Yes.
P2 has gone unchallenged at all times.
Yeah, that was my question. I was just asking for
Yes.
clarification.
Yes.
Page 142 at the bottom, is it possible that this is a fabricated document?
P7.
And it is P7, and I think my lord has pointed out the way P7 was introduced. Yes, thank you.
Thank you. Now, and when we go to the evidence of Mr. Lowe at page 1, starting from 145, when he started producing being shown the transfer from the company to ABSA towards the account of to the appellant, but very importantly, at page 150, he says that to the second question, he says that as the administrator, that he took cognizance of statement of affairs, and it is on the basis of a statement of affairs that he formed his opinion. And the next question, the question after that, I said I conducted and audited all the transactions. You can term it whichever way you want, but this is how it is. We go into the transactions, we go into the figures, we go into what is the status. Right. The next page, the second answer, the fifth line from the bottom of that answer. Because the others were more like operations, I do admit that there was some money that you put in the company. Here I'm referring to the 230,000 GBP which he allegedly paid into the accounts of the company. But there was some other money that went to you as well. But both were treated as part of the operation of the company. But this one was treated as a loan because it was disclosed as a loan even by the auditors, so this is why we concentrated only on this particular item. And the further question from the appellant, sorry, the company has received payments from me and for reasons not credited them to this alleged loan. Mr. Lowe goes on explaining, because there was some payments made to you as well, and the net amount is probably there is another 50 or 60,000 pounds which was net to you, so other items apart from the loan which was paid to you, and those were being treated as operating expenses or whatever. But the loan was a loan. That was completely separate. That was disclosed separately in the accounts. And this is why the other amount that you've said you've put into the company was not credited against this particular loan, because there was no documentary evidence to say that those amounts were against that loan. We took it that those amounts were against other payments that were made to you in the normal course of business. So the administrator at the time being questioned, I'm referring specifically to those 230,000 GBP, explanations were provided by the administrator with respect to such sum. And again, as usual, the appellant did not have any document to confront the administrator to prove the contrary. In any case, nothing was averred in the plea. With respect to ground to the other submissions made by my friend, when we come to my friend's interpretation of section 1599, which is found at page 514 of the brief, we don't deny the fact that by a unanimous resolution, the shareholders may approve payment and where there are reasonable grounds to believe that after the distribution, the company is likely to satisfy its solvency test. So, the argument, my friend, is raising is that that resolution dated 15th of February 2010 could have validated that transaction of 615,000 GBP. But as rightly pointed out and highlighted by your lordships, there is a very important test to be carried out, which is the test of solvency. My friend's argument is that at the time that the money was paid, or the monies were paid to the appellant in 4 different payments, whether the company was solvent or not could not be determined. True. However, the same applies to the time when that shareholder agreement, their shareholders' resolution was done. And it is my humble submission that it was an essential condition to be satisfied before any resolution could be done in favor of whoever under that section. So that is my point. And now, very importantly, my lord, my friend is making very much an issue about that difference between P2 and P7. My point is, the question which begs to be answered is whether the words "on demand," because P2 shouldn't be forgotten, that P2 is unchallenged and is accepted by the appellant. Would the words "on demand" present in P7 change the nature of the plaintiff's case, the respondent's case against the appellant. I will humbly submit in the negative. Why do I say this? I say this because by virtue of section 1597 at page 514 of the bundle BEB, which reads as follows. Where a loan is made in breach of subsection 5, the loan shall be voidable at the option of the company, and the loan shall be immediately, I'll stress on that, immediately repayable upon being avoided by the company, notwithstanding the terms of any agreement relating to the loan. Notwithstanding any terms of any agreement relating to the loan. So the moment it is voided, that amount is repayable immediately. So that, it is my humble submission, the moment the administrator has found that those transfers were done, there is no reason to that because this is P3, P4, P5, P6, show clearly that transfers have been done to the account of the appellant. Now, there is the evidence of the auditor confirming that those transfers tantamount to loans. So the moment the administrator concluded through his investigation, through the auditor's report, that those amounts represented a loan to the appellant, he was totally entitled to proceed under section 159 to void that loan, irrespective of whether the words on demand would be present or not. Now, there's the issue also with respect to, which is an important issue, with respect to the judge taking cognizance of that document in the bundle. This is how we started, actually. Like I said earlier, my lord, this is how it is in Mauritius. Probably it has to change in future. I don't know.
And when you say taking cognizance of that document, are we back to the
We're
February
to
resolution?
the shareholders' resolution.
All right.
Yeah. 50, because it revolves around that, like I said. How it happens in Mauritius, my lord, is that we place the whole bundle together with a different paper earmarking the different documents, 1 to 10, 1 whatever, plus the bundle.
But you haven't been able to show us that document.
Sorry?
That's what I asked you about. There's a notice of tender, I think. Was
No, but the bundle was there. We don't know whether it's just mentioned at page 95 or 97 that he put in that notice of tender by the attorney, actually.
right, but you haven't been able to show us that document.
We don't have it in the brief.
No.
We don't have it. But the bundle is there. This is referred to by the learned judge herself.
Yes.
Now, what my friend is saying is that because the bundle was there, that document, this is where the dissension happened between both sides, and this was written in our statement of facts. We submit that even if a document is in a bundle, it is a court of record. Each document has to be put in individually. And in fact, if we go to the proceedings before the Court of Civil Appeal, page. This is good. Page 264. When my friend is submitting, counsel is submitting at page 263, the last paragraph,
So is this at trial or in the Court of Appeal?
Court of Civil Appeal.
Right.
The last paragraph, my lords, I must admit in the way things unfolded, but it is my submission that the reasons that I will now expatiate on this document was put before a trial judge in a bundle of documents. We all agree as to that. And I address, yes, if I may be allowed to address your lordships on it, it is clear that this documents were not produced at trial. There is an admission that it wasn't produced at trial, one by one. I admit that, and it seems as I have seen that being done in cases before our courts, although I have not done myself, that it seems to be some kind of practice now, where a tender of documents intended to be produced is put as a separate brief of documents before a trial judge for ease of reference. This is what I stated earlier. I have seen it done. And then the learned CJ, as he was then, replies, makes a remark.
And sorry, who's SN, first of all? I don't do it myself.
Sorry, my lord?
Sorry, on page...
SN, SN?
Yes. Who is that speaking?
Probably, I don't know. SN, I don't know.
Right.
I don't do it myself, I don't know why it's there.
Right.
Anyway, I don't know about all this practice. This is not proper. Documents have to be put in one by one, and they have to be marked by the registrar. So we have it, in this particular case, that the documents remain in the bundle and were not put in one by one. And this is why when counsel replies to the appellant submission, he says, we are referring to a document which has not even been produced in court, formally, I mean. With respect to ground 3 and 4, my lord,
And can I just be clear? We looked previously at part of the transcript at trial where document P7 was introduced. Is that introduction pursuant to this formal introduction of documents one by one? Is that why?
yes, before any court, actually. Yes.
Right.
It should be one by one. Like when the plaintiff ushered in document was P2, P1.
It's given a number.
Yes. Marked by the registrar. P1 in this file.
Yes, I see.
Otherwise, it cannot be construed as being part of the proceedings.
So it would be D1, it was defendant's document.
Yeah, D1, D2, D3, that would have been.
I see. That's the significance of the piece.
Yes,
Yes, I hadn't picked that up. Yes, thank you. Yes, thank you.
Now, on the issue of ground 3, first of all, I find it quite strange that ground 3 and ground 4 are being pleaded in the alternative in any case. Our submission on this score, my lord, is very simple, that it is not the function...
Can you just remind us what was ground 3?
Ground 3 is the need to explain and justify findings by the Court of Civil Appeal.
So I'm looking at page
432.
432, yes.
432.
Yes, thank you.
On that score, my lord, I will humbly submit that it is not the function of the Court of Civil Appeal, of an appellate court, to come and rehearse every step of its reasoning. And it is not required to make an express pronouncement on each and every finding it makes. And on that score, we've quoted the judgment of English and Emery, which explains in detail the role of the appellate court in such cases. Now, my friend has, at page 433, underground 4, in the alternative. I don't quite understand why in the alternative, but then again. Erred in upholding the view of the learned trial judge that the authenticity or lack of it of document P7 could be of no avail to the appellant. On this ground, my lord, I will submit that given that there is already P2, which goes unchallenged, we have the evidence of the Mr. Nubby of Grant Thornton confirming that it is a loan which has gone unchallenged. We have the bank transfers. So it would be my humble submission that based on such pieces of evidence, the Court of Civil Appeal concluded whether P7 is true or not, there was enough evidence apart from P7 to confirm the liability of the appellant towards the company. And under ground 5, my friend refers to page 313, in fact the part of the judgment, page 313, where the Court of Civil Appeal says, at page 314 actually, the second paragraph, moreover, the learned trial judge pointed out that in any event could be of no avail. Yes. The next paragraph, the last sentence, however, as pointed out by learned counsel for the respondent, their shareholders' resolution are irrelevant and cannot save the appellant. Again, for the same reason I've enunciated just before. There were other pieces of evidence which were of essence to show the liability of the appellant. Now, my friend is reading a bit more into it, because in his submission he referred to the fact that because of that particular line, the Court of Civil Appeal had perused that document. I will humbly beg to differ, because the Court of Civil Appeal says in no uncertain terms, as pointed out by learned counsel for the respondent, there is at no place, nowhere mentioned that they have seen or perused or considered that document.
So do you say when the Court of Appeal says it's irrelevant, that ties in with the view that it wasn't pleaded, that this issue wasn't pleaded, and therefore it becomes irrelevant? Why do you submit it?
It's twofold, actually. It's irrelevant because there are other pieces of evidence, other documentary evidence, other oral evidence which have gone unchallenged, so that whether it's authentic or not, whether it's true or not, is not important in this particular case.
But we know from section 159, subsection 9, that you can have a defence if there's a unanimous resolution of the shareholders. So if it were open to the appellant to rely on the resolution for that purpose, it wouldn't be irrelevant, would it?
If he would have been allowed to do so. But right. Again, we come back to the pleadings.
Yeah, well, I think that's what my lord was putting to you. is the reason that it's irrelevant that it hadn't been properly pleaded? You seem to be making a separate point, which I didn't understand.
Right. So had it been ushered in, it could have been relevant. This is the point.
Yes. Which I think you've just agreed. So does it,
if you could allow me,
does it essentially come back
for 2
to
minutes?
the point that the court considered it hadn't been properly pleaded and therefore was irrelevant?
I believe that they relied upon the proceedings before the trial court. Because that resolution was not ushered in, so there was no relevancy talking about it. This is because it couldn't be produced.
And couldn't be produced because it hadn't been properly pleaded.
It wasn't produced because it wasn't pleaded. It wasn't added in the plea.
Yeah.
In fact, it is in that line that counsel for the then counsel for Respondent pleaded, submitted to the court. With respect to the arbitrary assessment of damages, my lord, I will humbly submit that it was within the discretion of the learned judge to come up with a global assessment in view of the evidence on record. The more so when Mr. Citation deponed with respect to the issue of prejudice at page 112.
Sorry, was that 192?
112.
112, sorry.
Yes, 112. So it starts from 11. Now, that's the last question at 111. Now you're also claiming a sum of £100,000 as damages. Can you explain to her ladyship why £100,000 are being asked from Mr. Aldridge as damages in this matter as well? The company, he goes on to give reasons why.
And I'm sorry, this is the evidence of Mr. Lowe, is it, or whose evidence is this?
Sorry, my lord?
Whose evidence is being transcribed here?
Yes. And then, this is not challenged, this piece of evidence...
No, but who is it being given by? Who is this evidence?
By the representative of the company, of Midco, by Mr. Citation.
Citation, thank you.
It starts from... sorry. It starts from 104.
Thank you.
The manager of corporate services, Midco.
Yes.
This is not challenged. And in fact, the £100,000 are, the prayer is for £100,000, and the judge decided to give only 2 million rupees as a global assessment. And
Can you just give me an indication as to that's well below 100,000, I think, isn't it?
Well, 2 million rupees is actually for £35,000.
So it's well below
Well below.
what was requested.
1/3 of the amount, approximately.
Yeah.
1/3 of the amount. And I will refer your lordships to the case of DDSR when it comes to lack of challenge by cross-examination. It's deemed to be accepted. This is already in the brief, in the bundle. This will be it, my lords. I think I have, within my time allocated, any questions I'm at your disposal?
No. Thank you very much for your submissions. Yeah, so Mr. Abdullah, you have 15 minutes.
Yes. My Lord, just to pick up on a few sound bites from my learned friend's submissions. First of all, since you asked a question, my Lord, about the bundle of documents and the notice tender of evidence,
Yes.
it so happens, as you would have remarked, that my instructing attorney is the same attorney who was instructing Mr. Aldridge in the matter since the outset.
Right.
So he has retained a copy of the defendant's notice tender of evidence.
Right.
So just for you to have a visual, This is what it looks like. Of course, we could not include it in the reproduced record given the issue as to whether it was produced or not.
But as I now understand the procedure, in fact, it may be that it doesn't matter very much whether there's a tender notice or not, because as it's been explained to us, the procedure is documents have to be introduced into evidence one by one.
Yes, and we don't dispute that.
No. Okay.
What we say, given the exceptionality in the present matter, when Mr. Aldridge was conducting his own case, the judge already had before her, the trial judge, had this bundle of documents, which is usually put in for ease of reference, and she started referring to parts of it. And she, in fact, requested that it would have been better that it had been properly paginated. She spelled out her requirements. For example, you will see that the transcript shows that one of the documents was the constitution of the company, and she opened the bundle and started referring to parts of that constitution. And then when Mr. Aldridge, with the impression that was given, started referring to the shareholders' resolutions and referred to the page, item number, etc., as part of that bundle of documents, this is where he was stopped from doing that on the basis that it had not been pleaded. So this was the focus of the objections to the issue surrounding the shareholders' resolutions. If we stick to that issue of the shareholders' resolutions, my lords, what you have just engaged in your exchanges with my learned friend for the respondent, pertaining to the findings of the Court of Civil Appeal that the shareholders' resolutions are irrelevant, is an exercise of guesswork. We do not know. The Court of Civil Appeal haven't told us what their lordships meant by the shareholders are irrelevant. What they have said, they were alluding to the submissions of the respondent. And what they say specifically, page 314, third paragraph, as pointed out by learned counsel for the respondent. This phrase in my submission, my lords, can mean at least two things. Either it is irrelevant because it was not pleaded, either it is irrelevant because the proposition of the respondent at the trial, as is transcripted, was that whatever happened afterwards, that is, after the financial transactions themselves, was, in the words of then counsel for the respondent, neither here nor there. So what was then the irrelevance that their lordships of the Court of Civil Appeal were alluding to? What was their understanding of the irrelevance? We do not know.
Well, why shouldn't one read the judgment of the Court of Appeal as a whole? So read the word irrelevant in the context of what they said on the previous page, that it was not open to the appellant to introduce these materials because they hadn't been pleaded, or averments which would have made them material or relevant evidence had not been pleaded.
I'm not sure that this is the only conclusion that we can arrive at when we read even the earlier paragraph that you've just alluded to, my lord, because when you look at the very paragraph where this phrase comes from, their lordships of the Court of Civil Appeal are referring to my own submissions before them, where I had submitted that since the bundle of documents which formed part of the brief contained the shareholders' resolutions of the 15th of February 2010, it was not proper for the learned trial judge to ignore those resolutions. So I would tend to believe and read from their conclusions when they use the word however, the shareholders' resolutions are irrelevant and cannot save the appellant.
Was there a submission made by the Respondents' Council that they are irrelevant in any event?
No, the only submission that was made factually was, in terms of practice and pleadings, it was that it was not pleaded. And the only other proposition of the respondent was that it was irrelevant, presumably in law, because according to then counsel for the respondent, whatever happened after the financial transactions was neither here nor there. The phrase neither here nor there were his specific words.
What's the reference for that?
Yes. You have two references. Yeah. During the trial, this phrase was used at page 134 when objection was taken. That's 134. And this position was reiterated during submissions before the Court of Civil Appeal at 303. I'm sure you'll find it, my lords, unless you want to have a look at it now. So 134,
Yeah.
Mr. Ramburn then saying whatever happened afterwards is neither here nor there. And
That's in the context of the matter not being pleaded. So I'm looking at page 134.
yes, but there's this very specific proposition here which for me indicates then learned counsel's understanding and appreciation of the law. What he seems to be suggesting is that there can be no subsequent approval of this transaction. When
Well, I'm not sure that's the obvious interpretation at 134, because he comes back to talk about the plea.
yes,
He cannot now try at this stage to introduce matters which are not pleaded. I agree the phrase neither here nor there,
Yeah.
following whatever happened afterwards, is your strong point. But I think in the overall context of the whole reply, it looks as if he's just saying it's irrelevant because it's not been pleaded.
I think he's saying two things at the same time. He's saying that it's not, he's playing all the cards available to him at the time. He's saying it's not pleaded in any event, and he's expressing an opinion that whatever may have happened afterwards between the company and its shareholders, presumably I take it to mean after the last transfer was made in 2009, and cumulatively this led to £615,000 being in the hands of Mr. Aldridge. According to then counsel for the respondent, any subsequent approval was irrelevant. And like I told you...
But I think you would accept, in the light of what you've just said, that when the Court of Appeal refer to that and say it's irrelevant, they may well, a possible interpretation is that it was because of the pleading point.
It's a possible interpretation, but it's one of three interpretations, my lord. It could be the pleading point, it could be the impossibility of subsequent shareholders' approval point, which I think would be equally erroneous in law, and it could also be that they have looked at the document. Because in the same paragraph of the judgment, they pick up on the fact that I had drawn their attention that the document is in the bundle of documents and it was not proper to ignore them. So perhaps they had reacted to what I had said, and contrary to what the learned trial judge had done, they had not ignored the contents of the document.
And you gave us another reference, page 303,
Yes.
in the Court of Appeal. Which was the bit that you wanted to rely on for that?
303?
Top of the page,
Yes.
but they explain neither here nor there. I still say so because it was not a live issue before the trial judge.
Yes.
They seems to be saying it's neither here nor there because it simply wasn't an issue because of the pleading point.
But if you look at line 2,
Yes.
my lord,
Subsequent resolution, I know.
there is, yes, subsequent resolution. The emphasis is all on the ex post facto approval. And may I remind you of my position in law?
You understand that?
Section 272, if ever there's any doubt as to section 1599 being a section which authorizes ex post facto ratification by shareholders, and even if we take it to mean that section 1599 only speaks of prior shareholders' unanimous approval, which would render inapplicable section 159 altogether, section 272 of the Act leaves no room for doubt that the legislative scheme is that you can have either prior or subsequent shareholders' approval, which leads to the inapplicability of section 159. When you look at section 272, and the 11th schedule thereof, which we have put in the supplemental bundle, it makes it amply clear that once there is unanimous agreement by shareholders, and there's the specific item of making of a loan to a director under 272 subsection 2E, then by virtue of section 272 1B, which spells out that the provisions of this act referred to in the 11th schedule shall not apply in relation to that action, we have also appended for your benefit the 11th schedule on the last page of the supplemental bundle, which excludes the application of Section 159 altogether. So what I take this to mean is that once shareholders have approved a loan to a director unanimously, it is not open to the company to have recourse to a cause of action under Section 159 at all. And this is the utmost relevance of the shareholders' resolutions of the 15th of February 2010, because chronologically, it had already happened before the initiating process in the present proceedings, which started in May 2011 under the initial plaint with summons. Our position in law, therefore, which the courts below failed to appreciate, is that in view of the shareholders' resolutions of February 2010 that Mr. Aldridge systematically sought to rely upon, it was not dependent on his pleaded case. It came to the root of the question whether this cause of action was open to the plaintiff in the first place, and we submit that it wasn't. And this joins me to one of the very first things that my friend said in his submissions earlier. He takes issue with the general traverse and the very economical plea to say that it was unfair for the respondent company as a plaintiff not to know what is the case it has to meet. He said the plaintiff has the right to know what is the case it has to meet. But before that, my lord, and an entirely separate issue, is the responsibility of the plaintiff itself. The plaintiff has its own responsibility by way of the legal and evidential burden which rests upon it, independent of what is pleaded by the defense. It has the responsibility in law, on the facts, on the evidence, to discharge its own burden. My lords, you would be familiar with the possibilities that cases can be won or lost at the close of the plaintiff's case without the defendant having to come and say anything at all. Even in Mauritius, you have what is frequently referred to as make-out cases, which are undefended, unresisted claims, where the courts, at any level, still expect that even if there's no plea on the record, this does not mean that the plaintiff has a free evidential hand and that there is no standard to be established. The burden is still on the plaintiff. Irrespective of what is said, or rather what is not said by the defense, the plaintiff has to discharge the burden to the required standard, the balance of probabilities. So that's why we go in this appeal, we draw your attention to the fact that at the root of it all, my appreciation of the evidence and my appreciation of the law is that this plaintiff had simply failed to establish its cause of action against the defendant. The plea comes afterwards. And I've told you, we take the plea for what it is. It could have been better. It probably should have, but it is what it is. And with that in mind, the real question is, in the normal and proper sequence of events, before we even arrived at the defense case, at the close of the plaintiff's case, did this respondent company establish entitlement to the prayers in the plaint, that is, for a refund of £615,000. And that's why it is also not correct for my learned friend, for the respondent, to contradict his own client's position on the £230,000. My friend is repeating today what then learned counsel for the respondent said on appeal before the Court of Civil Appeal, that the £230,000 was allegedly part of the operation's current account, and that this is the explanation that had been provided before the trial court. This is a manifest contradiction in my view, and may I once again, for the sake of clarity, draw your attention to EB, the previous judgment involving the parties, the 2013 one, EB 528.
So, Mr. Abdul, just be aware you're in your last 2 minutes now.
Yeah. So at EB 528, it is made very clear that the senior manager, corporate services of MIDCO, affirmed an affidavit on behalf of the respondent and confirmed at page 530 and 531 that the £230,000 in December 2009 was a part repayment of the alleged unlawful loan. So we submit that counsel cannot now go against his client's own position on the matter. When it comes to documents P2 and P7, my lords, my friend is telling you that P7 does not change the nature of the transaction. We submit that it does, because P7 purports to include terms that weren't there. The words on demand were not the only words that were added. You have the words nil and nil being added for interest and repayment terms. This intrinsically has the possibility of converting the transaction from one which was not a loan to one which suddenly was being relied upon as being a loan. And my submission in law is that it is only if it is a loan that the transaction falls under section 159. And this was the very first and foremost element of the cause of action that the respondent company had to establish, and it simply did not. The transfers evidenced by documents P3 to P6 only evidence that transfers were made, but these transfers don't mean anything in the legal context. It can simply mean that it was consideration for the sale of shares, as was previously validated. And we still expect, my lord, that in the teeth of the judgment, there should have been more express pronouncements on the salient issues in the case, so that we would not have had to indulge in much of guesswork as we have had to do today. And it would have been more judicious to do so.
Yes.
I mean, you would accept, as I understand your submissions, that if we were to take the view that the cause of action is established by showing that a loan was made, and that the question of the unanimous shareholder agreement goes to a defence, that your pleading point, you would concede, I think, that you have inadequately pleaded, because everything you've said here is that all of that goes to the cause of action and should have been pleaded by the claimant company.
Yes.
Whereas that's not the case if we're against you on that matter, I think.
It's not only an if, they've actually pleaded it in the plaint, but if ever you do find, as the outcome of these proceedings, that the burden, according to you, was not on the plaintiff to establish this as a constitutive element of the cause of action on their part, and that it was only a defense, section 1599 or 272 of the Act only makes available a defense to the party who intends to rely on it, then of course the plea would be inadequate in that respect.
Thank you.
Thank you very much.
With the permission of the board, just for enlightenment, the answer to that irrelevancy issue is found at page 242 of the EB.
Sorry, page
242.
242.
Where the respondent particularizes what is irrelevancy.
And help us, where on that page? Oh, in the middle, under ground 5.
Under ground 4 and 5, the unanimous shareholders' resolution dated 15th of February is irrelevant. It never formed part of the appellant's plea, and appellant cannot now introduce this new element. And the same is repeated under ground 5. This is on the basis of which the learned judges on appeal.
Yes, thank you very much.
Thank you.
The board is grateful for the submissions that we've received both orally and in writing. We will reserve our judgment. This hearing is now adjourned. Thank you very much.